abusuya mi channel misa so mo akwa abaso no koso family channel so abusuya hada so ye be media jecha abusuya eye honorable Matthew Yindam yes honorable Matthew Yindam Kpandai MP MP abusuya eye de a Tamale High Court e the ruling bi e ba ya omocho mo nsem mu a kwan afa so ewi ni eye election 2024 no enye genuine nti say yes call for eye election eye rerun na chese ye fa chese ye fa eye kwan paso say edi elect a MP was our constituency. Nabusia and I had Speaker Bagbin wakasa. Yes, Speaker Bagbin edim common ne. Nabusia dia nsem no ka kire a Kpandai MP. Honorable Matthew Yindam. Abusia yemko ni nkonko nsem Speaker Bagbin. Just so odia tuja na enya asem keto abusia ene de ensem wo ho ensem e ho ankasa abusia be se wa se. Obe subscribe be like na wabo aso ahia ma for person be tie na abusia. Omo anya bi atie. Yencha ne nkonko nsem a honorable yes Speaker Bagbin abusuan say odi atudwa fa honorable Matthew Yindam Kpandai MP asisi am no work say ye ade a by election and as we say election rerun abusuan ba be koso a enya asem koto yenti nsam a Speaker Bagbin say ne waka e de ache papa yi wo parliament yenti amra sesi a ye da
Kwame, take me to parliament now. Yenti the ruling of the Speaker of Parliament, Right Honorable Sumana Alban Bagbin, on the Honorable Yindam case of following the Tamale High Court ruling, said there were some electoral irregularities caused in the 2024 elections, or Kpandai to be specific.
Layer that may prevent changes to the member status within the meaning of Article 97 and 99 of the Constitution. The House's attention is also brought to Article 105 of the 1992 Constitution, which provides that a person who sits or votes in Parliament, and I quote, knowing or having reasonable grounds for knowing, unquote, that he is not entitled to do so, commits an offense. It is crucial to emphasize that Article 105 is penal in nature should the member know that he ought not to be in the chamber and he participates in the activities in the chamber. Honorable members, it's therefore premature to say that the Honorable Matthew Yindam is disqualified from entering and participating in the proceedings of the House, because this period still falls within the 7 days mandatory stay of execution of the order. Honorable members, this is not a declaratory order, it is an executive order that was delivered by the High Court. And so the honorable member is right to have been in the House yesterday and to have participated in the proceedings. Honorable members, as I indicated, I had a second job to do, and that had to do with the ruling. The ruling is in respect of the complaint of contempt that was brought against the minority leader, Honorable Osahin Alexander Kwamina Afenyo-Markin, member for Ifutu and minority leader of the House. Honorable members, on Tuesday, 11th November 2025, this House received a formal complaint under Order 6 and 33 from Honorable Mahama Ayarga, Member of Parliament for Boko Central and Majority Leader. The complaint alleges that Honorable Osahin Alexander Kwamina Afenyo-Markin, member for Efutu and minority leader, has engaged in conduct which, if substantiated, may constitute contempt of Parliament and a breach of parliamentary privilege pursuant to Orders 30 and 31-0 of our standing orders. The complaint arises from events said to have occurred during the sitting of the ECOWAS Parliament in Port Harcourt, River State, Nigeria, from 25th to 28th September 2025. According to Honorable Ayarga, Honorable Afenyo Markin attended that session of the ECOWAS Parliament in contravention of a duly adopted resolution of this House, which excluded his name from Ghana's delegation to that regional parliament. The complainant asserts further that this conduct amounts to an affront to the authority and dignity of Parliament, and accordingly invites the Speaker to refer the matter to the Committee on Privileges and Immunities for inquiry and recommendation to the House. Honorable members, as I indicated at the close of the majority leader's submission that day, the standing orders prescribe the procedure to be followed when allegations of contempt or breach of privilege are raised. It falls to the Speaker in the first instance to determine whether the facts disclosed in the complaint established a prima facie case warranting referral to the committee. Members recall that I deferred my ruling to the next day, and that was to be Wednesday, 12 November 2025. However, the pressures of business on the order paper made it impossible to deliver the ruling on that day. I am now in a position to do so. In considering this matter, I have reflected carefully on the facts alleged, the standing orders, and the relevant constitutional and statutory provisions governing 1, the authority of Parliament, 2, the binding force of parliamentary resolutions, and 3, the scope of Parliament's contempt jurisdiction. What is the nature and effect of a resolution of Parliament? Honorable members, a resolution of Parliament is a formal act through which the House expresses its collective will on a matter properly before it. Once adopted, a resolution becomes a binding decision of the House until it is rescinded, suspended, or varied in accordance with the standing orders of the House. A resolution therefore has continuing effect, and the Speaker, as the presiding authority, is bound to give effect to it. While the Speaker may clarify the scope or meaning of a resolution, he cannot amend, modify, or disregard it unilaterally. Honorable members, this principle reflects the doctrine of collective responsibility. When Parliament speaks through a resolution, that decision binds all members, irrespective of political affiliation, leadership status, or personal opinion. As Eskime reminds us, and I quote Eskime, the dignity of Parliament depends upon the observation of its rules, and the authority of Parliament depends upon their enforcement, unquote. This is the foundation upon which parliamentary collective responsibility rests. So what is the power and scope of Parliament's contempt jurisdiction? Contempt of Parliament refers to any act or omission that obstructs, impedes, or undermines Parliament in the performance of its functions, or which affronts its dignity, or tends either directly or indirectly to obstruct, impede, undermine Parliament in the performance of its functions, or affront the dignity of Parliament. Parliament's power to address contempt is inherent in its constitutional status as a coordinate arm of government and is expressly recognized under Article 122 of the Constitution, Order 30 of the Standing Orders, and Section 26 of the Parliament Act 1965, Act 300. Honorable members, the jurisdiction to sanction contempt is not limited to acts committed within the chamber. The relevant test is whether the conduct, wherever it occurs, has a direct or indirect tendency to obstruct, diminish, or bring Parliament into disrepute or ridicule. Parliament may therefore exercise its contempt jurisdiction over conduct occurring outside the presence of the House, where such conduct undermines the institution's authority or impairs its ability to give effect to its decisions. Honorable members, I note that the specific instances of contempt listed in the standing orders, such as disorderly behavior, deceit, or disobedience of an order issued by the presiding officer, do not expressly identify non-compliance with or disregard of a resolution as a distinct ground of contempt. A resolution, as earlier observed, is a decision of Parliament, not an order of the Speaker. There is therefore no express provision making its breach a stand-alone category of contempt. However, Section 26 of Act 300 makes clear that the enumeration of contempt grounds is not exhaustive. Parliament retains the right to treat as contempt any act that impedes its functions or affronts its dignity. Order 31A similarly contemplates conduct, whether specific or general, that brings Parliament into disrepute or undermines its institutional authority. It is within this broader category that the present allegation must be assessed. Honorable members, it is useful to consider what constitutes an affront to the dignity or authority of Parliament. Orders 30C and 31 prove directly or indirectly brings Parliament into disrepute or which undermines its authority, reputation, or dignity may amount to contempt. These capture behavior that, while not obstructing proceedings, undermines Parliament's standing, coherence, or credibility. An affront to the dignity or authority of Parliament may arise where a member's conduct A. challenges or disregards a valid act or decision of the House. B. diminishes the institutional authority of Parliament or the Speaker. C. undermines public confidence in the discipline, unity, or dignity of Parliament. Or D. brings Parliament into disrepute before state organs or external bodies. Unlike other specific grounds of contempt set out in the standing orders, this category focuses not on the place where the act occurred, but on its effect. Conduct that conveys the impression that Parliament's decision may be ignored without consequence qualify as an affront to dignity, even if committed outside the presence of the House. Democratic experience across the world teaches that institutions endure not by their formal design alone, but by the conduct of those entrusted with them. The strength of this House, therefore, rests not merely in its constitutional design, but in the consistent respect members accord to its decisions and processes. Honorable members, having reviewed the complaint, the standing orders, and the governing principles, I am satisfied that the matter raised prima facie implicates the dignity and institutional integrity of this House. Pursuant to Order 34.1, I therefore refer the matter, the complaint lodged by the Honourable Member for Boko Central and a majority leader to the Committee on Privileges and Immunities for examination, inquiry, investigation, and report to the House. The committee is directed to 1. Ascertain the relevant facts giving rise to the complaint, including the actions taken by the House and by the Honourable Member concerned. 2. Review those actions taken within the framework of our standing orders and the applicable protocols of the ECOWAS Parliament. 3. Determine whether the conduct, if established, constitutes contempt of Parliament or a breach of privilege under Orders 30 and 31.
Now, yeah,
and 4.
Honorable opinion marking, of course, Obekaya, yeah, Honorable Dafiama Pomonim Penufubiaka, Ebeka say, Honorable Nindam, it's answered Tamale High Court. Aka said there were some electoral irregularities in Tiensan Court to Abanfo from. That is, we know who can say, but nobody participated in proceedings in Parliament. In T or Quambisono, there is uncle free. Omuyino a free Mukrakra. Speaker Caswad ruling beba. Na OT speaker. Na chese inquiry say near maybe Biguna Quansono. Because wow, we say on the tour. That was the first ruling. Now the second ruling, no. Obeka say a year honorable opinion marking. I can not ECOWAS Parliament. Ama maybe Dria Omuyini free ECOWAS Parliament was replaced. It's in a say or ECOWAS Parliament one. Abra ye a for nothing. Na ye and I ratify omo kanina member countries. Ghana for parliamentarians representing Ghana Koya, they were not ratified. Yanjoma to Yentimi and Swam, Yentimi and Swam in Adentia, honorable opinion marking. So Abba, not just a Ubuko, not just any Pamino, and Abba for one position. A banisano, Yentimi and Swam. Not just a denim guase, Abba, I'm almost signed to many Sansa, Sa, Eba Ghana High. And on a majority leader, Mubekaya or Rezi Quam said, there be opinion marking. Yanyanisa. Yanyanisa, when this was swan, who feel at the better apotro, the nisso sound. It wouldn't mean fat when anyone could name apotro if ye. Yanyanisa, a sentinel, or catch them as the speaker say, Uncle only on any Mahondia, a year honorable opinion marking. A year. Speaker deferred his ruling. I say, I'm a permanent. What in the ruling, member. Speaker say, and of course, I'm say, Osha near Manua, a course noa, a dear anche ye. It's in Comobuno, not just say, at the Parliament and Union cry a buffon. Ombacas Ghana cry when you organized. Eh? Because no less a person than minority leader of the biggest opposition party in Ghana, knowing very well. And again, Papa or a lawyer. And I'll be linking him to Samuel Kanye, Efre, the Tamale Court and Judge Kangaroo Court, and I'm like, wow, like seriously? Into while refer matter no to the Privileges Committee. Wamu anabeshe no omaka sasem. My main kase Honorable Samson Asaka Wingobet adjoining Samsona Abdul Manaf Rabiu and so ewa yebekum na yedi enkomo but fameko near Honorable opinion.
The judiciary must know that their actions and inactions to serve the interests of whoever their paymaster is has the tendency of destroying our peaceful republic. We will not mince words. They can conspire to call us one by one for a so-called contempt of court. We are criticizing their shameful conduct. We are not afraid. We are ready to be in Nsawam for their so-called contempt. The world will see their disgraceful conduct. We will not sit aloof and allow them to undermine the very rule of law that they are supposed to protect. How can a judge who calls himself a judge sit in court and misconduct himself in such a manner and expect the country to be quiet? Now here is where the matter becomes even more extraordinary. This order, an order with massive political, legal and democratic consequences, was pronounced without the court's full judgments, as I've stated supra. There were no written reasons, no factual findings, no legal analysis, just a naked directive issued into the public domain. And the whole constituency is now being told that there must be a rerun. I am a practicing lawyer of experience at the bar. I understand that courts occasionally deliver rulings with reasons to follow. But such a practice is the exception, not the rule. And it is never an acceptable approach when the stakes are this high. The judiciary must know that their actions and inactions to serve the interests of whoever their paymaster is has the tendency of destroying our peaceful republic. We will not mince words. They can conspire to call us one by one for a so-called contempt of court. We are criticizing their shameful conduct. We are not afraid. We are ready to be in Nsawam for their so-called contempt. The world will see their disgraceful conduct. We will not sit aloof and allow them to undermine the very rule of law that they are supposed to protect. How can a judge who calls himself a judge sit in court and misconduct himself in such a manner and expect...
Because, say, as experienced person at the bar, now also contempt and is so called. And you see, I am waiting for that day. I mean, so man no be against any court to be better some who be abremi. I'm also waiting. Now court to be entrance him who be bremi say, maybe they watch me contempt because me ma can say metia. Na ma bo honorable apenyo tape ya tell say, is he a superhuman being? I'm just waiting. I'm just imagining say any other person say me utudako kwa brabu bi ansa and any of the soldiers I crowd say Ghana be fan into my pefra ana can send be singer anka court be send bail bi ana muhunu say this is recorded in history na muhunu say say me atwagui as a court nyina da e okrom hey so obi nso koka sensem no a court no nkoso na because mama yehunu say bibia no ever contempt of court. Parliament odo sabe nkum kire parliament a yes be the contempt of parliament ana meboa be the contempt of parliament where honorable opinion is coming from be the contempt of parliament. And as a legal luminary with so much experience like you claim, now you make such reckless statement. It is funny the kind of a country you build it like an animal farm. Who the animal empire so when you authority there, when you do be scapegoat, Your authority no timi kense munu no afan wedi. That is the kind of a country I team. And I don't know say ever. So sad spectacle. Now question me bisa say since when Honorable Apenyo Marking who say Ghana court a kangaroo court since when? Hey, since when? That's a Bafu Bunny court. A kangaroo court there. What do you call Tokonus court? Me say, Sir Chief Justice Bafu Bunny, ne court a kangaroo court. What do you call Mame Araba Tokonus court? And nobody tree court and and I'm not surprised Honorable Apenyo is crying foul because Onya Chief Justice Bia or the Assembly Court within 2 hours obey panel judges Amano Onya bill. That kind of shameful act is gone. It's gone. Now there's a resetting agenda and Yansafuaba. Tomo ye name Yansam and Yansafo ne Abumaino. A Jimmy Foni Hobio. That kind of and Crofonu and Kamubenya they just empan. You will not get it again. So I'm not surprised to say you throwing your weight about. Now when they are more court, Montana. Now one train so be bepa, move flow to Dako. Make them say there is no contempt of court. Because the Apenyo Kaino, if you fail to act, then there's nothing like contempt of court. Minority Leader Apenyo Marking cited for contempt and referred to Privileges Committee. Where you're different, where has to do with Yakasimo Nkwekowa's parliament. Anna or Kwekowa's parliament, ye unifrim, and also want to say no Kwe. It was Ghanaian delegation, they were not able to be ratified. And the Speaker has referred him to the Privileges Committee. But I'm talking about proper contempt of court. As I cannot. What's it so called?